The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Morning, please be seated. All right, we have, our first case is Clinchfield Coal versus DOWCP. And Ms. Prince, I'm happy to hear from you.
May it please the court, Kendra Prince for the petitioner, Clinchfield Coal Company. Your Honors, this case turns on whether the administrative law judge's findings of total disability were rational, supported by substantial evidence, and in accordance with the law. Clinchfield here today asserts they were not. Here, the ALJ has failed to weigh the contrary probative evidence as required by the Administrative Procedures Act and the case law. The Benefits Review Board here has compounded those issues by affirming the ALJ's findings without adequate, meaningful review. Now, the ALJ here has relied on two pulmonary function tests, one dated October 29, 2014, and the other February 23, 2018, to find the claimant was totally disabled. Now, the arguments for these are slightly different, so I'd like to address one in turn. Turning to the October 2014 PFT, I think it's important to note that this PFT was done in connection with the Department of Labor examination and thus is subject to the quality oversights. Section 718-103C specifically mandates that no results shall constitute evidence of pulmonary impairment unless it meets the standards set forth in Appendix B. Appendix B further provides that maximum effort is required. It specifically lists out a litany of things required, but specifically that 7 seconds of exhalation or until an obvious plateau is reached.
Counsel, doesn't Appendix B often also say that if it's established that one or more of the standards have not been met, the claims adjuster may consider such fact in determining the evidentiary weight to be given to the results of the function test? Isn't that also part of Appendix B?
It is part of the Appendix B, Your Honor, but we have experts in this case who are saying that given the inadequacies in this PFT, that it is unreliable and it does not meet those quality standards listed in Appendix B.
So how are we supposed to read the language of 718-101, the substantial compliance language, and the evidentiary weight language in Appendix B under your theory of the case? It seems to me you're reading both of those phrases out of the relevant regulatory language.
Your Honor, employer would assert that Section 718-103C, specifically referring to the pulmonary function test, is what would be controlling here. And 718-103C specifically mandates, it provides that no results can constitute evidence of pulmonary impairment unless it meets the standards set forth in Appendix B. And employer would assert that.
And then the sentence that you just read continues to say, in accordance with the requirements of this section and Appendix B. And this section meaning 718, Section 718, right?
Yes, Your Honor.
And Section 718 speaks about substantial compliance, and Appendix B speaks about evidentiary weight.
Yes, Your Honor.
And so how are we not reading those phrases out of the regulatory language if we follow your analysis? In other words, what's the meaning of those phrases under your theory
Under my
of the regulation?
Your Honor, essentially, to be in substantial compliance, it needs to comply with the regulation, with Appendix B. And to be in substantial compliance, meaning that most of those need to be met, or there needs to be an explanation for why one is immaterial to the pulmonary function test.
Where's your explanation requirement in the regulation? Is there a requirement that there be an explanation?
No, Your Honor. There is a presumption that the PFT is in compliance, but when there is contrary probative evidence, an expert must review, or the ALJ must review that contrary probative evidence and determine if the PFT in effect is valid and reliable.
And substantial compliance is a part of that evaluation, isn't it, by the statute? We look at, the metric is a lot, not a lot more, but it's more elastic than what you concede, right?
Yes, Your Honor, but the case law and the APA still requires the ALJ to explain those findings and to weigh that contrary probative evidence.
The 6 seconds plus a half or a nanosecond is pretty close to compliance with 7 seconds, isn't it?
It might be pretty close, but it still doesn't meet the,
It's substantial, isn't it? If you did it from a mathematical standpoint, it's gotta be high 90s, isn't it?
it may be, but
It is.
it still doesn't reach that specific standard. It's still, being in substantial compliance means that an employer's assertion that while it might not reach the 7 seconds of exhalation, it might meet other standards
So
listed.
you're equating strict and substantial compliance to be the same? You're saying that strict compliance is the same thing as substantial? Because otherwise, I don't see any delta that you're conceding between those two.
It wouldn't be a strict compliance, but it would be
So you concede it's not
compliance-
strict, right?
Yes, Your Honor.
Okay.
But it would be a compliance with various of the things listed out in Appendix B. While a claimant may not have 7 seconds of exhalation, they could meet other standards listed and be in substantial compliance.
And isn't that what happened here? That the other requirements were met other than the number of seconds?
There were the number of seconds for exhalation, but all three of the or four of the experts that reviewed, there's 3 experts that reviewed one PFT and 3 experts that reviewed the other PFT. All of those experts said that it was not just the 7 seconds of exhalation, it's the fact that the claimant didn't achieve maximum effort, that he didn't breathe in the full amount of air and breathe out the full amount of air as required when they're administering these PFTs. And the reason that that is important is that when you administer this PFT, you have to have the full expiration and inspiration so that we can understand what the claimant's current impairment is. And that's why these qualities.
Is effort the sole criterion of the validity of a PFT?
Say that again, Your Honor.
Is effort the sole criterion for evaluation of the validity of the PFT?
Effort is not the sole criteria, Your Honor. There are other litany of criteria listed, and that these pulmonary experts take into consideration when they determine whether a pulmonary function test is reliable indicator of pulmonary impairment.
What concerns me is that you're trying to split the findings so fine and talking about complete compliance versus substantial compliance. And I wonder if we're not stripping the interim presumption of its effect. Normally, the interim presumption, and in this case, this individual has worked a long number of years in the mines, and I haven't sat on many cases where the interim presumption was validly invoked and where it was but the benefit of it was overturned on a question where different experts reached different conclusions as to the validity of the PFT. And if these circumstances, if we were to reverse here, I wonder if we wouldn't be denying the interim presumption of the beneficial effect that the miner is entitled to. And the interim presumption is critical to the whole Black Lung Act proof scheme. And in order to overturn it, I would expect to see something fairly conclusive among the different physicians who had evaluated, the different experts who had evaluated the PFT. And I don't see that here.
Your Honor, while the 15-year interim presumption does apply, it's still the claimant's burden to prove he is totally disabled and to invoke the 15-year presumption that he has pneumoconiosis and it contributed to that disability. But importantly, the case law still requires ALJ to review the contrary probative evidence and explain his reasoning for weighing or not weighing the evidence. Simply here, we don't know why the ALJ discredited Dr. Wren or Dr. Sargent or Dr. Fino or Dr. Rosenberg. We know that the ALJ did credit Dr. Ajarapu in regards to the 2014 PFT.
Well, I thought Dr. Fino actually thought the October 2014 test was good and was valid, and yet he was representing, or he was generally comes down on the side of the company here, and even here, he thought the test was valid.
Your Honor, I believe Dr. Fino did not find the test invalid, but he said it was a better effort than what he saw with his own testing. He still didn't ultimately find the test itself to be valid, is my understanding of Dr.
Well, that
Fino's
may be
opinion.
your understanding. My understanding was a little bit different. I thought he felt the test to be a good test and a valid test.
But importantly, we still don't know how the ALJ weighed Dr. Fino's opinion in regards to this PFT. We don't know because the ALJ didn't explain why Dr. Fino was entitled to wait or not entitled to wait, or how he weighed Dr. Fino's opinion against or with Dr. Ajarapu and Dr. Renavaya. You know, the case law still requires, at a bare minimum, that the ALJ weigh that contrary probative evidence. And, Your Honors, we reviewed the Southern Ohio case that you all had, this court had sent us, and we're asking for the same standard that ALJ put forth. In that Southern Ohio case, we have an expert saying that this PFT is invalid because the claimant did not, or was suffering from an acute illness. And then we have the DOL expert saying, oh, this PFT is valid. And then we have an ALJ going into the record and saying, well, this expert is discredited for these reasons, and provided reasons from the record for why that expert would not be entitled to any weight. We're asking the court in this case to do the same thing, to require the ALJ to explain why these experts are entitled to no weight.
As I recall, the ALJ explicitly considered the minor's effort and cooperation in connection with the PFTs and thought they were sufficient. I mean, but I did think that, as I recall, if I've misread the record, then that's my problem, but as I recall it, the ALJ did explicitly consider the minor's effort and cooperation.
The ALJ did discuss the minor's effort and cooperation, but the ALJ didn't discuss how he weighed Dr. Sargent, Dr. Fino, and Dr. Wren's opinion against Dr. Ajarapu's opinion and Dr. Renavaya's
I think that
opinion.
JA 53 is exactly what you're describing. All of the reports are addressed by the ALJ, and this just seems to me a classic battle of the experts. I actually have an unrelated question, if I may. The regulations provide 4 methods for establishing disability. One of those is the PFT, and then there are 3 others, including the 4th, which is a physician exercising reasonable medical judgment that a respiratory or pulmonary condition prohibits the claimant from engaging in employment. So it strikes me that the 4th is separate and apart from the PFTs, and therefore the ALJ could consider the physician's reasonable medical judgment that the claimant was no longer able to work, was completely disabled, based on all of the things that the physician here considered, including an examination and diagnosis. And so the PFTs, which you argue are invalid, were but one consideration, but the regulations allow the physician exercising reasonable judgment to make a determination separate and apart from the PFTs standing on their own, does it not?
That is correct, but the ALJ still must explain how, even if the PFTs were not taken into consideration and that expert opinion is not based on the PFTs, the ALJ must still explain why and how this expert is entitled to weight, given inadequacies in the PFT evidence that they ultimately relied on in making that opinion. So it essentially sours their opinion. If the PFT evidence is in fact invalid, then the ALJ must explain why their opinion otherwise is entitled to weight.
Well, as I say, I thought ALJ did discuss effort and cooperation, but what I'm concerned about is that we are losing the forest for the trees here, because as Judge Berner points out, the effort and cooperation is but one factor in the PFT, and the PFT is but one factor in the overall assessment of pneumoconiosis, and the interim presumption has to weigh in at some point. And so by focusing on this one little thing, I wonder if we are not departing from the proof scheme in the way that Congress has set forth. Congress wanted people that had worked in the mines a substantial period of time to recover benefits. And that would be particularly true in the case where the experts are not conclusive. And as Judge Berner points out, it really was a battle of the experts. And to overturn it here just seems to me we're overlooking what Congress was getting at. That's the problem I'm having.
May I answer, Your Honor?
Yes, of course.
Congress did implement the 15-year, the presumption to ensure that miners who worked 15 years in the coal mine industry could more easily receive benefits. However, the regulations still put in place that it was the claimant's burden. It's the miner's burden to prove that they are totally disabled. And a part of that proving total disability includes this multifactorial test of ABGs, pulmonary function test, and medical opinions. And parsing those out is part of the claimant's burden, Your Honor.
I just want to respond to you. You just said "and," the regulation actually says "or," right?
Yes,
So
Your Honor, I apologize, or.
it could be any of those things, that there are 4 methods of establishing disability. So
That is correct.
PFTs is just one method,
That is correct.
but a physician exercising reasoned medical judgment is a different method.
That is correct, Your Honor. And can I make one brief conclusory statement?
Thank you. You have some rebuttal time, I
Oh,
think.
yes, I'll do it then, thank you.
Ms. Wolf, we're happy to hear from you.
Thank you. Good morning, Your Honors, and may it please the court. My name is Rachel Wolf, and I represent the respondent in this claim, Mr. Vernon Vanderpool. Claimant submits to this court that the board properly upheld the ALJ's decision of finding of disability because it's supported by substantial evidence, rationale, and in accordance with law. The ALJ properly applied the quality standards in Part 718 of the regulations in Appendix B in determining that the 1029-14 pulmonary function test was valid and supports a finding of total disability. My friend, Ms. Prince, has just suggested that we don't know how the ALJ ruled, that the ALJ did not provide a rationale of discrediting Dr. Fino's opinion. The ALJ took over 4 pages to discuss the 1029-14 pulmonary function test. This court has held in Island Creek Coal Company versus Blankenship that the duty of explanation is satisfied if the reviewing court can discern what the ALJ did and why the ALJ did it. I think it's important to note, and I think Judge Gregory, you made a good point, the framers noted that it's a substantial compliance requirement in Part 718. It's not a absolute compliance, it's not a total compliance. The judge weighed the evidence. Additionally, Appendix B notes that if one or more of the criteria of Appendix B are not met, the judge has the discretion to determine the weight to go to such test, and that is what the judge did here on the 1029-14 pulmonary function test. The framers of the regulations are giving the fact finder a lot of discretion to make that determination for non-conforming test. The employer might not agree with how the ALJ weighed the evidence, but the ALJ probably found that the validation opinions of Drs. Rand, Sargent, and Fino were not well documented or well reasoned, and that the 1029-14 PFT was valid. If you considering the Southern Ohio Coal Company case as persuasive evidence, that opinion said that the fact finder is allowed to make validation opinions that are and determine whether those opinions are well-reasoned and well-documented. If you look at Dr. Sargent's opinion with regard to the 1029-14, the ALJ properly found that it was not well-documented or well-reasoned. The ALJ, in fact, Dr. Sargent's opinion was equivocal and vague. Dr. Sargent noted in his,
One of the things
I'm
that
sorry.
concerns me if we were to remand this case, what good would it do? The ALJ would say something like, as I have said before, I credit Dr. Jarapu's opinions over Dr. Fino and Sargent, and then it would, and the ALJ would discuss why, as it's already done. So, I mean, I don't see where a remand, I assume you agree, I don't see what good a remand's gonna do.
I do agree, Judge Wilkinson. I think the judge thoroughly explained his decisions. He explained, he considered all contrary evidence. He considered the opinions of Drs. Wren, Fino, and Sargent with regard to the 1029-14 pulmonary function test. He considered Dr. Jarapu's opinion, Dr. Jarapu's supplemental opinion, the validation study by Dr. Reina Vea, the technicians' comments on the pulmonary function test about cooperation and effort. I'll also point to subsection 2G of Appendix B. It states that minors with a rapid decline in lung function or minors with obstructive lung disease are not likely to meet the reproducibility values of the FEV1 values within a 5% variance. In this PFT, the 1029-14, Mr. Vanderpool did meet the reproducibilities on the FEV1 values. He excelled for over 6 seconds, and Dr. Jarapu explained that in her supplemental opinion, which is one of the many reasons that the ALJ gave this pulmonary function test weight.
In that section you just read, it specifies that failure to meet the standard should be clearly noted in the test report by the physician conducting or reviewing the test. Was the failure to meet the standard clearly noted?
It was noted in Dr. Jarapu's supplemental opinion, yes, Your Honor.
The bottom line is that fact-finding matters.
Yes, Your Honor. Claimant would submit that the fact-finding matters. With regard to the 223-18 pulmonary function test, claimant submits that the ALJ properly found that the 223-18 was valid and supported a finding of disability. This PFT did not have to be in compliance with Appendix B or 718-103. It was taken in the course of claimant's treatment. The ALJ, again, how did he get to his decision and why did he do, and did he explain that? The ALJ did explain the 223-18 pulmonary function test. He noted that the claimant had good cooperation and effort according to the technician's notes. He noted that the American Thoracic Society reciprocity criteria was met and the pre-criteria was met. He noted that the test said it was confirmed. It was faxed to the claimant's family physician, meaning, and I believe that shows that the ALJ properly inferred, which he's allowed to do. He's allowed to make inferences from the evidence, although he can't substitute his opinion, that it was a reliable test that could be used in the course of his treatment. As Dr. Jarapu.
When I was looking at the opinion, I said, ALJ sounds like he did a pretty good job.
I believe so, Your Honor. And we also agree that the ALJ properly found that the medical opinion evidence based on Dr. Jarapu's 1029-14 pulmonary function test supported his finding a disability. And we would ask that that this decision by the board be upheld. I will take any more questions if the court has any.
Thank you, Judge Gregory. Judge Byrne?
No, thank you.
We have no more questions. Ms. Wolf,
Yes, Your Honor.
you have some rebuttal time? I'm sorry, Ms. Prince.
You're fine.
Excuse me.
Your Honors, this is not just who the ALJ chose out of competing experts. It's the fact that we don't know how the ALJ weighed the experts. And while, yes, the ALJ did discuss all of these expert opinions, we still don't know why he discredited these opinions. And that is the crux of the issue. And like in Milburn-Collery versus the Hicks case, where the ALJ cited no reason to discredit Dr. Rasmussen's opinion over Dr. Zaldivar, that's what we have here. We have no reason why Dr. Wren's opinion was discredited. The ALJ discusses Dr. Wren's opinion, and the ALJ discusses Dr. Fino and Dr. Sargent and Dr. Rosenberg's opinions, but we don't know why the ALJ did not believe them. And as part of the ALJ's requirement is to explain those findings. The ALJ also seems to cite a board case called Laird versus, excuse me, I don't have the full citation. Laird versus Freeman United Coal in coming to these instances that, well, Dr. Jarapu said, quote, "This is what the claimant could do, and I give Dr. Jarapu weight." And that's within the ALJ's discretion. He can give Dr. Jarapu weight, but he still must explain why the other experts are entitled to no weight. And if they are entitled to weight, the ALJ must then take those opinions and weigh them against the contrary probative evidence. And I'd also like to discuss the later 2018 treatment record PFT. While it is not subject to the quality standards, here the ALJ has also mischaracterized the record, essentially. The ALJ seems to put importance that this was a confirmed report, but if you look at the actual report, who it was confirmed by, there is a question mark. Additionally, the ALJ seems to imply that Dr. Jarapu formed some type of opinion on this test. However, the absolute maximum that the record can support is that Dr. Jarapu ordered this as part of the claimant's treatment. It was signed by Ann Davis, and beside her name says CRT. Otherwise, the machine-printed comments note good effort or met. That is the maximum amount on the PFT. There is no treatment record in this record where Dr. Jarapu forms some type of opinion regarding validity. Additionally, in regards to those machine-printed comments, earlier in this decision, the ALJ reviewed something similar, where the machine-printed comments noted it was a good effort. And the ALJ correctly determined that that was entitled to no weight because there's no understanding of what the machine meant by saying it met or was good effort. So the ALJ seems to also imply that Dr. Jarapu faxed this report to Dr. Brockhurst, the claimant's primary care physician, but there's no indication, again, in the record that is supported that Dr. Jarapu either instructed or is the one to fax the report. The ALJ makes a substantial amount of inferences regarding this PFT, but still doesn't weigh that contrary probative evidence against the PFT on which she ultimately relied. There's 3 other experts in the record. He does discuss those opinions, but he doesn't explain why they are entitled to no weight regarding the reliability of this PFT. It's not enough that the ALJ relies on one expert to find that the PFTs are reliable and should be given weight. The ALJ must still weigh that opinion against the contrary probative evidence and must determine what weight to be given to the contrary probative evidence.
Let me ask you a question, and this is certainly not to be a trick question at all, because if it's out of your bailiwick, let me know, but so much has been said about the PFT. Basically, it's, someone says, empty all of the air out of your lungs, right?
That is correct, Your Honor.
Right, and the
Yes.
longer you can go, the better you are, or the better the test results, perhaps, right? Perhaps? Is that right?
You were just supposed to expel all of the air out of your lungs.
And my question is, expelling all of your air, what does that do to the veracity of the test results? That's important, isn't it? What does it do to the veracity of the test results, the longer you exhale?
Well,
If you don't know, I mean, that's fine.
I'm not a medical expert, Your Honor, but what I will say is, from my understanding, is that it ensures that the test reflects the claimant's true maximum ability to be able to determine how much impairment there is.
Exactly, and that's what my good friend and colleague, Judge Wilkinson, was saying to you. that is in terms of, your people said that there was no evidence, it was good effort, no malingering, and those things, Mr. Vanderpool, and therefore, the effort was verified by the contract physicians you're talking about, so, and they noted that. The fact that if they had said, yeah, that 6.3, it's malingering, but they said that's the best effort. So as the pneumoconiosis progresses, couldn't you have a reduced amount of seconds you have to exhale, or you couldn't exhale for that as long? In other words, you're so sick that you couldn't get to 4, but does that mean that you don't have that's what I'm saying? But in other words, as it progresses, I guess you might go, that's all I can do. And so the question is, malingering is important in your contract. People say there's no malingering, so why, that's what I'm saying. How do you connect those two?
In regards to effort, Your Honor, while the exhalation is a main part, the other thing is the flow volume loops. And that's how experts determine, based on those flow volume loops, whether the claimant achieved his maximum effort in the PFT. So even if the claimant isn't able to do absolutely everything they could, as long as the flow volume loops show, adequate effort, then that's how an expert determines validity.
Yeah, and they do that by a malingering. They make a clinical finding of malingering if they think it's not.
Yes, Your Honor.
And here, your contract people said there was no malingering, and it was a good effort. That's what they said.
Dr. Wren,
Am I wrong about that? It said, it's noted there was acknowledged a good effort, no malingering.
Dr. Wren listed a litany of issues with that pulmonary function test and did not find it valid or reliable in finding the claimant disabled, Your Honor.
2 of your doctors didn't say that? Well,
I
think I
don't
have to
believe so.
agree
I
with
believe
you.
Dr.
I think what the ALJ says is that your experts said that the problems could be related to other conditions such as heart disease, muscle weakness, or obesity. In other words, that there could be other reasons, I guess, that the claimant was unable to comply completely with the requirements of the exam. What strikes me as odd is that if somebody's so sick that they can't exhale for 7 seconds, it seems like proof of disability if they're unable to exhale for 7 seconds. And over again, the inability to exhale for 7 seconds seems to show disability.
Your Honor, even claimants who are very, very sick are still able to achieve valid pulmonary function tests. They're just really low values.
One of the troubles that I have is with all these different layers of litigation where we go from the ALJ to the Benefits Review Board and then up here. And it takes years sometimes for these individuals to recover the benefits that they're due. And in the meantime, their disability gets worse. In many instances, they die. In other instances, if they die, their spouse has to wait an exceedingly long time before getting the benefits. In other words, this is a long, drawn-out process in which people who have really suffered respiratory and pulmonary disease through prolonged exposure to the dust that emanates from coal mines. And to add to the years and years it takes them to recover, a remand that elongates this process even further, seems to me at some point we have to take account of the old axiom that justice delayed is justice denied.
Your Honor, I would like to point out that this claim would be covered by the trust fund, so the claimant is currently receiving benefits in that interim litigation period.
Thank you.
Thank you, Your Honors.
Judge Gregory, do you have
Thank you, Your Honors.
Thank you. We'll come down and greet counsel and move to the next case. Please be seated. We're prepared to hear argument in our second case, Payne versus Moser. Mr. Clark, please come forward.
May it please the court, Your Honor, Andrew Clark, counsel for Jeffrey Payne, who is the appellant in this matter, and also the plaintiff down in district court. This is a civil rights matter alleging excessive force. At the outset, I do want to let the court know that we are voluntarily dropping our issue number 2 as it deals with search and seizure. So today we'll be speaking about issue 1 and issue 3. Issue 1 is the first issue that I'm going to take up, and that has to do with whether or not the district court erred by granting summary judgment as to count 1, which is the excessive use of force. And the district court erred when they made impermissible factual determinations about the evidence in this case. Understand that during the summary judgment portion of a case, the court is allowed to review the evidence and make determinations based on the evidence, but the court can't sit in the place of the jury and making determinations about the evidence in the case. And that's exactly what the district court judge did here. When looking at the facts of this case on August 2nd of 2022, Jeffrey Payne was someone that was uninvolved in any of the initial parts of this case. The record shows that there was an individual named Hector who was being investigated by the Fairfax County Police Department, the Narcotics Division, and he was the first one that was arrested. All of this happened on one day. After he was arrested, he then informed and said that he could set up a deal with Jeffrey Payne. Jeffrey Payne was called on the phone.
Is there a dispute over the question that he first reached into the center console and then started to raise his arm?
Absolutely, Your Honor, and that's the main crux of the dispute here. And the evidence that's presented by the plaintiff is in the form of a deposition conducted by the defendant in this case of Jeffrey Payne himself, who says that after his vehicle was rammed by multiple unmarked vehicles, that at the time that he was rammed, he did not see any police sirens. At that point, he stopped. There's a dispute about whether or not the officer ever provided any commands prior to shooting Mr. Payne. Mr. Payne says that he did not hear any commands. The officer, Moser, says that he did provide commands prior to shooting. Even in his affidavit, it's unclear on what the commands were that he actually provided.
There's
I'm sorry.
sometimes, though, when you, these situations unfold rapidly and you don't have time necessarily to give a command if someone raises his arm and aims a firearm at you. I asked if there was a dispute about the fact that he reached for the console and then raised his arm.
Yes.
And you said there was a dispute about this and that and the rest, and about hearing commands, but I didn't hear you say that there was a dispute about the fact that he raised his arm.
Yes, Your Honor, there is a dispute about him raising his arms. In his deposition, after there was a collision, that's the point where the officer says that he moves over to the center console. We're disputing whether or not he moved over to the center console and then raised his hands.
Matter of fact, your client said he did not.
Correct. He said that he just
He
stayed.
flatly said he did not do those things what they consider to be furtive actions, correct?
That's absolutely correct, Your Honor. And at that point, the dispute is Officer Moser says that he gave commands. In his affidavit, he just says he identified himself as an officer. He doesn't say what the commands were, whether he told him to put his hands up, put his hands out of the window at that point. Now, later on, he does say that he asked him.
What
I'm sorry.
reason, what reason would he have to shoot if not to save his buddy's life?
Oh, absolutely, Your Honor. So prior to this,
Why would he be shooting if it wasn't to save his buddy's life?
so prior to this, there was Hector, who was the confidential informant, stated that Mr. Payne was armed. When they were conducting the controlled buy, prior to the buy being completed and Mr. Payne driving off, then again, they thought that he was armed and dangerous without any evidence that he was. So when he rams the vehicle, that's giving him.
The question is whether the officers had a reasonable belief that he was armed, and when you have a combination of the informant who said that he carried a gun during his drug deals, and when he's fleeing from the police and hopping a curb, and then reaching to the center console and then starting to raise his arm. The question is whether there's a reasonable belief on the part of the officer that the situation was life-threatening. And we can point to this dispute and that dispute on the periphery of something. But on those central events, was it an unreasonable belief that it was a life-threatening situation that the officer was confronted with?
Yes, Your Honor. The circumstances of that night show that it was unreasonable for this officer to believe that any of those other officers' life was in danger. The reason being is that, first off, Mr. Payne was trying to get away from the, later on find out the officers, but remember, they're in unmarked vehicles, not using their police sirens, so there's no way for Mr. Payne to know who is following him. So after they ram the vehicle in a heavily tinted car, with Officer Moser standing behind him on a much higher position, there's no way, and that's where the jury comes in, is that there's no way that Officer Moser could have seen inside of that vehicle to determine whether or not Mr. Payne was reaching for anything at that time. And that's even more reason why the fact that he was in a cast at that time gives them even more of a reason to not believe that he was a danger.
What possible reason would he have to shoot if there was no sense of endangerment?
Based on the tainted evidence that was provided.
Did he just fire the firearm for the heck of it?
And Your Honor, that is a question for the jury because of the amount of time, the lack of amount of time that passes between the ramming of the vehicle and then the officers shooting Mr. Payne. At that point, there's no time for any kind of compliance. There's no time for Officer Moser to determine whether or not there is a firearm. And we know by the fact of the later investigation that there was no firearm. So for him to make that determination after just ramming a vehicle and basing it, even in his words, basing it off of one movement, which we're disputing.
Does it matter that there was later found that there was no gun if the officer had a reasonable belief based on the informant's report and the police chase and some other things that there was, that the individual was armed? It's a question of what a reasonable belief was at the time, wasn't it?
Yes, and that's where all the circumstances come into play around what was going on and why the officers were there that night, what was going on with the chase, how Mr. Payne's car was pinned in so he couldn't move to begin with. He couldn't get out of the vehicle or anything like that.
Well,
and then also his vantage point. I'm sorry, Your Honor.
Why wouldn't it be pinned in if he was on a chase and hopping a curb and the like?
So, Your Honor, the chase piece of it is, I think that's part of the limited facts that I don't think either party disputes, that Mr. Payne was not evading police arrests because they did not use their police sirens. The defendants say that they used the police sirens at the moment that they rammed the vehicle. And we're saying that Mr. Payne did not see the police sirens prior to getting shot. So
Can
we
I ask you about
dispute.
these tactics used by the police, the TVI and the pit tactics, that surrounding him in these dark cars, unmarked, no sirens, no lights? I know that it's well established that these tactics can be a seizure for purposes of the Fourth Amendment. You've just said to us that you are forfeiting your seizure, your second claim. I'm curious if it's your contention that this use of this tactical vehicle intercept can also be, in and of itself, excessive force for purposes of Fourth Amendment. In other words, is your argument solely based on the shooting, or is it based also on the tactical vehicle intercept and the precision immobilization technique? I was struck by the ramming of a vehicle when there is no chase underway.
Absolutely, Your Honor, and that's part of count one. So count two has to do with after he is apprehended in the search that took place that wasn't part of Officer Mosier's doing.
So your
but it's-
excessive force claim is based not only on the shooting, but also on the techniques employed by the police in ramming the vehicle and surrounding the vehicle and not allowing him to leave the parking lot.
Correct, because, well, he was able to leave the parking lot.
Right, not able to drive away.
Well, he was able to leave the parking lot. Well, he was driving for some time before they ever made any kind of moves to use that technique, which is also problematic. And we're bringing in the totality of the circumstances, and that's part of it in terms of the excessive force used, is they said that we have probable cause to arrest Mr. Payne even just by him showing up. So then why are they waiting for him to leave the parking lot? Why are they waiting for him to go and stop at an intersection? And then they're only using this technique after he has the fear of what's actually going on. Am I being robbed? Am I getting ready to be killed? And then it's only after he's rammed that he sees the police lights and he realizes that it's police. But at that point, there's no time for any kind of compliance because Officer Moser discharges his firearm almost immediately after getting out of the vehicle.
Why were they in a high-speed chase to begin with?
It was not a high-speed chase, Your Honor. He was just following the vehicle. So prior to that, there was the controlled buy that was supposed to occur between Mr. Payne and Hector, the confidential informant. Mr. Payne, based on his deposition, testimony, his recordings, that he got spooked about what was going on because this is somebody that was familiar to him, that apparently they had done business before in the past. So when there was another individual, Mr. Payne got spooked, and he did leave the scene at that point. It wasn't a high.
control buy.
No, there was
Right.
never a
It's
control buy.
Simple. There was no control buy.
Correct.
Right.
Correct.
Nor was there a chase.
No, there was not a chase.
They rammed his vehicle.
Correct.
Right. That's deadly force, isn't it?
That's correct, Your Honor.
Right.
It's a very dangerous thing to do in that circumstance, especially when he's going off of the curb to try to avoid what he believes is possibly a robbery at that point. All right. So going to 3, now we're talking about gross negligence in count 3. We can't get to gross negligence unless we overcome our burden in count 1. But here, there's again enough facts for the jury to decide this issue also of gross negligence. You have a set of facts where these officers are in plain clothes, not using their police authority until after the point that they use excessive force. And that's a dispute of facts because the defendant is saying that they did use their police authority prior to the use of excessive force, but they also don't clarify what authority was actually being used. So all of this should be going to the jury for the jury to decide the evidence and not for the district court to have decided this case on summary
But
judgment.
before the jury, if we were to agree with you on summary judgment, wouldn't we need to reach the issue of qualified immunity, or wouldn't the district court need to reach that issue before the case went to a jury?
So the district court did not decide the case on qualified immunity. the thought is that that was an alternative measure, but they didn't actually make any analysis based
that's,
on qualified immunity, which is why we
That's
didn't
not-
appeal.
That doesn't prohibit us from resolving the case on qualified immunity because you can affirm on any ground.
And the court is looking at this case de novo, correct? And the court would be able to consider
Understood,
qualified
but
immunity.
the qualified immunity applies in a situation where the law is unclear.
Correct, Your Honor, but here, the law is clear. If we're looking at just looking at Graham v. Conner, the law is clear that if we're looking at the factors here, that you're looking at the severity of the crime at issue. This is a hand-to-hand narcotics deal between people that are known to each other. And, Your Honor, I do only have 3 seconds left, but I'd like to just finish my thought if I
I'm
can.
concerned in these kind of situations that we write opinions that restrict the abilities of officers to act to save their own lives or to save the lives of their buddies. And in these kind of rapidly unfolding situations, officers should not be given complete latitude, but neither should they be subject to excessive restrictions. And I don't want to put the law in a position where the officers are precluded from taking actions to preserve their very lives and that of their colleagues.
And Your Honor, if I can just briefly respond to that.
Sure
to
you
that.
may.
Yes, Your Honor. Also, there is also an importance to preserve human life as well. And what's different in this case, which is different in other cases that this court has decided, is that these officers did not use their police powers, which was then refused, which then led to deadly force. And that's the difference in this case, and that's the distinguishing
You
point.
say that, but there are all kinds of police officers who do proceed in unmarked cars. Many of the, I would say a great many officers are in unmarked vehicles. And the law doesn't prescribe that.
But the law does prescribe the fact that if you're using your power as an officer
Well,
to,
let's put it this way. Looking into a console and raising your arm, even if you were raising your arm to shoot another civilian, it wouldn't matter in terms of what you're talking about, which is the police authority. It would not matter whether someone was trying to kill a police officer or whether someone was trying to kill another, just a private citizen, a non-officer. And you made the point, which I agree with, that we have to underscore the value of human life, but that's at stake here. This kind of situations, it's just, I just don't think that the law can say to officers that you can't try to disarm a person or whatever when you feel like your life is in danger or that of your comrade is in danger. This would have a very sharp effect on police officers because the message would go out that you not only you can't take steps to save your own life, but you can't even take steps to save your buddy's life. And the sense of camaraderie within police departments, not, sometimes it may be unhealthy, but many times that sense of camaraderie is necessary to law enforcement. And to say that you can't take steps to save your buddy's life, that would land hard.
And Your Honor, I don't disagree with you, but the key point that I want the court to take away is that the dispute of fact here is whether or not that arm was raised, whether or not there was that furtive movement in the vehicle, and whether or not that officer could have seen, and the credibility of that officer and being able to see that furtive movement being done. And that's where this case
I
turns.
don't understand what alternative reason, what reason would an officer have to shoot someone if there was no sense of endangerment?
And Your Honor, that would be for the jury to decide based on what Mr. Payne's testimony is versus what Mr. Moser's testimony is.
But you have to have a genuine dispute of material fact, not just a quote dispute. That word genuine in the Federal Rules of Civil Procedure is important. And I'm not sure that there's I don't know what reason he would have done to fire a single shot to disarm someone. What reason would there be to do that? I know you can say there's a dispute and that's for the jury and that's a fair point, but there has to be a genuine dispute over this, and that's what I'm unclear on.
Understand, Your Honor, and the genuine dispute that we're saying is an officer's ability to observe what he's writing in his affidavit. And the fact that both vehicles were heavily tinted, this was at night. Even in Mr. Payne's own testimony, he had trouble seeing out of the windows of the vehicle that he was in. So for the officer to say that he saw this movement occurring, that's where there's a genuine issue of material fact.
Thank you very much. Appreciate your argument. I'm going to ask Judge Gregory if he has any questions of you. I have none. Judge Burns.
Thank you, Your Honor.
All right, thank you, sir. You have some time reserved for rebuttal as well.
Yes, thank you, Your Honor.
Good morning, Kimberly Balcom here
Welcome.
on behalf of Sergeant Joshua Mosier. May it please the court, I think the important starting
Can
point,
you put that microphone, I want to be sure that we
thank
hear
you.
you.
Is that better?
Okay,
Thank you.
Thanks.
The important starting point here is not what the appellant claims on appeal occurred during this incident. I think we need to focus on what were the facts that were before the district court, and were those facts genuinely in dispute? Were they material facts? And I focus on the court's ruling in the Hanafi case that dictates that when we look at particularly a summary judgment motion on appeal, we focus on what was the record before the district court, and did the district court make reasonable findings based upon that record?
And how do we credit those facts at that point in summary judgment in terms of who does it weigh in favor of?
In this instance,
And not in this instance, just in any instance. You're on summary judgment, who does the presumption in terms of inferences weigh in favor of? The moving party or the non-moving party?
ultimately, it's obviously the moving party's burden, but it's the non-moving party in opposition of summary judgment to bring forward facts pointing to the record with specific cites to the record that brings into material dispute or genuine dispute those material facts.
Let's cut to the chase. I mean, it's a material dispute as to whether or not there was any furtive action at all.
I disagree, Your Honor,
Okay.
for two reasons.
Go
The
ahead.
first is that in opposition to summary judgment, the non-moving party has to identify which of the moving party's facts they want to dispute before the court. And what we had here was a lack in Mr. Payne's opposition of any indication that he was refuting Sergeant Mosier's material facts. And in specific, based on counsel's argument today, that, he claims now that his windows were tinted and that was too dark for Sergeant Mosier to be able to see in. But one of Sergeant Mosier's facts was fact number 56, where he established that he illuminated the interior of Mr. Payne's vehicle with his flashlight, and that he was able to see Mr. Payne's movements after the conclusion of that traffic stop.
Okay, that's one, so he could see what he said he saw. Go ahead.
Exactly. The second one, Your Honor, is, this thought that it is in dispute what motions were happening inside the car is refuted by not only Mr. Payne's failure in his opposition to refute Sergeant Mosier's facts 57 and 58, which establish what Mosier perceived when he illuminated the interior of the vehicle and saw the motions that Mr. Payne was making.
Mr. Payne said he didn't make those motions.
The
You can't
problem.
get away, counsel, you can't get away from that. Is that true or not? Didn't he
It is
say-
true that he said that in his opposition, Your Honor. The problem is that in saying that or claiming that in his opposition, he doesn't cite to a particular part of the record. He cites to his entire deposition transcript and attaches his entire deposition transcript for the district court.
Did you cite anything where he said he admitted that he had furtive action?
With regard to his particular
No, that he-
position,
no, wait a minute. Did he admit that there were furtive actions?
his argument, Your Honor, isn't that he
Oh, you
admits
answered
that
my
he did
question?
it. I am, Your Honor.
Okay,
It's
go ahead.
that when he opposes summary judgment, he doesn't say, I didn't reach or I didn't move. He says, my left arm was in a cast and it would have been impossible for me to reach for a firearm or hold a firearm, supported by references to the record where there was no firearm found in the car. And so really what he's claiming in opposition to summary judgment is there was no firearm in the car, so I obviously wasn't reaching for a firearm, and my left arm was in a cast. And so the argument that Sergeant Mosier didn't see what Sergeant Mosier claims to have seen is based on this assertion, I couldn't have done it because my left arm was in a cast.
No, it's not. He said, not only did I not do it, but I'm in a condition where I couldn't do it.
Right, and that alleged condition was directly refuted by the record, where at his deposition, over and over again, Mr. Payne admitted that it was his right arm that was in a cast. It wasn't the arm that Sergeant Mosier saw moving within the vehicle that Mr. Payne later opposed summary judgment by saying it would have been impossible for
So
me
it's
to
his
do
left
that.
arm, right?
It was his right arm that was in a
No,
cast.
but so it was the left arm that was moving?
That's correct.
So he had something on his right, so he reached over.
That's the motion that Sergeant Mosier saw.
But he said, he didn't say, he said, he denied that.
He denied it on the basis, the factual basis, that his left arm was in a cast. It was impossible for me to
But he
reach for
still
a firearm.
denied it, though.
He denied, again, Your Honor, he denied it by citing to his entire deposition transcript. The
That's like
portions,
saying, well, did you steal this wallet off this desk? I was at home at the time. So I deny because I didn't say I didn't steal the wallet. I just said I was someplace else.
and if that,
Right?
if that individual, I think you're right, Your Honor, and if that individual supported that assertion, I was at home, by a citation to the record that was developed in discovery that would support that claim, then you would be in a different posture than what we're in right now. The failure here is a procedural failure of Mr. Payne to point the district court by citing to the record that was developed in discovery in support of his claims. And he failed to do that. And all of the citations that are contained in his opposition brief are to portions of his deposition transcript that don't have anything to do with the denial that what Sergeant Mosier perceived at the conclusion of that stop didn't happen. He doesn't say that by citing to a portion of his deposition transcript where that's established. And I would draw the court's attention to the Cray case. I think it's instructive on this point. Cray was a case before this court where a non-moving party in summary judgment filed their opposition without filing anything associated with the record. They lost summary judgment and they filed a motion to reconsider. As part of the motion to reconsider, they attached pages and pages of affidavits, deposition transcripts, but didn't cite the district court to particular parts of that record that would establish the veracity of that claim or that that claim could be supported by admissible evidence at trial.
So your claim is not that there's not a genuine dispute of material fact. Your argument, in fact, is that counsel failed to point to the exact page in the deposition where that genuine dispute of material fact was established. That the opposition brief made the argument but failed to cite to the specific line and page in the deposition, even though the deposition was attached, and even though the deposition actually creates a genuine issue of material fact. It was essentially, in your argument, a failure of counsel to point to that page and line number, and on that basis, you want us to affirm summary judgment.
That is what happened. And I would point you to the Cray case.
So it's not that there's not a genuine issue of material fact in the record below, it's simply that counsel failed to point to the exact page.
That did happen. I think there's an extra argument that goes along with that, and that is that in opposing summary judgment, Mr. Payne decided to couch his objection to this issue of what was his position immediately before he got shot or when he got shot as being, I couldn't have reached for a firearm because my left arm was in a cast and there was no firearm in the car, which is, every time he talks about it in his opposition, it is as part of that more global argument. It was impossible for me to reach for a firearm because my left arm was in a cast. What he does there is create a situation where it's not brought into genuine dispute what his position was or what Sergeant Mosier perceived prior to discharging his firearm, because again, there's a failure to refute or to claim that he's refuting.
Well, I mean, I'm reading the deposition here. It's not that hard to read. He says, well, I tried to look back because I can't really move because of the cast on my arm. I'm trying to look back over my left shoulder. I couldn't see nothing. So he said, I'm just sitting there. I don't see no lights. It's just dark. It's just high beams. Nobody's saying nothing. So he says in his deposition, he was just sitting there and he couldn't move. I don't know what more he could say.
Correct, Your Honor.
Movement, what the requirement is that there be furtive movement, and he says, I couldn't move.
And had he argued that in his opposition by citing to his deposition transcript, and the pages that you're reading in the deposition transcript were not cited to in the opposition, and so
The
the district.
deposition transcript was, but not the page. So we get back to my
Exactly.
question, which is, your argument is fundamentally based on a failure of counsel to point to the exact line and page in the deposition transcript.
Which this court in the Cray case has specifically ruled the district court has no obligation to read the entire record that the non-moving party puts forth to try to find evidence that would find in favor or would hold in favor of that person. And so here we have the same situation. We've got a plaintiff who, in opposing summary judgment, fails to point the court to any particular portion of the deposition transcript that would establish that it was impossible for him to have reached for a firearm because he has his arm in a left cast. The district court, under this court's authority, had no obligation to read that deposition transcript. The other thing that happened as a result of Mr. Payne's failure to point to the deposition is that he avoided additional evidence that exists in favor of Sergeant Mosier that would have directly refuted his claim that he didn't move or he didn't reach for anything. And what that was is a recreation that was conducted by the Fairfax County Police Department's crime scene unit, where they staged the vehicles in exactly the same position at the scene at the same time of day. Sergeant Mosier participated in it, and a detective sat in Mr. Payne's front seat in the position that Mr. Payne was sitting in, and he was Mr. Payne's size. When they did the recreation, the detective sat still, and what the crime scene detective, through their observation and measurements, concluded
So
was
I think part of what you're saying is that even if he had pointed to a specific part of the deposition testimony, and I think your point is well taken, that you've got to give the district court some help here, and that's why someone's represented by counsel. But I understand you to make not only that point, which I thought was a fair one, but the additional point that even if the attorney had pointed to the specific place in the deposition testimony, that specific part in the deposition testimony would not actually have refuted Moser's version of events, because Moser was saying, I saw this, and a specific place in the deposition testimony would not have refuted the claim that that's what he saw.
Exactly.
So you've got two problems here. You've got the initial problem that my good colleague Judge Berner points out about the failure of lawyers to give reasonable help and assistance to the district court and not just dump a record or a long deposition testimony. You know, lawyers are supposed to sharpen the issues, and it wasn't done. And, but not only that, the specific points that could have been, or might have been, or may have been cited, don't refute what Sergeant Moser is saying he saw.
Exactly, I agree with you, Your Honor. And it's not only that they don't refute it, but,
There are duplicate problems here.
right, counsel specifically refused or chose not to, in his opposition, oppose any of Sergeant Moser's material facts. And so he's stuck with this perception that Sergeant Moser had. Sergeant Moser illuminates the interior of that vehicle. He has the ability to because he's got a flashlight. That's not disputed. And his perception was.
It's undisputed that he had a flashlight
Exactly,
and that he looked into the interior of the vehicle.
exactly.
And I do not know, it's also undisputed, is it not, that the informant told him that, look, this guy is a drug dealer and he carries a gun. Now, it later comes out that he didn't have, that there wasn't a gun present. But that doesn't speak to whether there was a reasonable belief on the part of the police officer at the time that there was a gun in evidence, or that there was a gun on his person. And he had an informant telling him that. So there are multiple problems here with the case. And, you know, these are hard cases because nobody wants anybody to be wounded in any way, shape, or form, but you just cannot have the impression go out that this court is not protective of an officer's opportunity, of an officer's ability to protect his own life and that of his buddy. That lands really hard, and it's a rough kind of thing, given the facts here.
I agree, Your Honor.
Given the facts here.
And certainly Sergeant Moser is one of those people who would never want to hurt someone else, but he testified very clearly in his affidavit, which is unrefuted by Mr. Payne.
Is
that
there any evidence here that this police officer was a renegade or had further disciplinary proceedings brought before him? I mean, does he have a bad rap sheet as
Absolutely
these
not.
things go?
Absolutely
There's
not.
nothing.
Right.
This is the first scratch, if that's what it is.
That is correct.
On this man's record. He's not one of those individuals that's run off the rails. There's no evidence of that, and I'm sure if there had been evidence of that, it would have been in the summary judgment. And you know there are people who are in any police force who are bad apples and bad actors. But this isn't, as far as the summary judgment record is concerned, this is not there.
That's correct. That's correct. And Your Honor, on the point about whether Sergeant Moser reasonably could conclude that Mr. Payne was someone who might be armed when they were encountering.
He had a flashlight looking into the car.
That's correct, Your Honor. And we have, you know, the individual who's being viewed, and I take your point, Your Honor, there was no distribution. When the undercover detective got out of the confidential informant's vehicle and tried to approach Mr. Payne's vehicle, he was not willing to engage in that transaction, and that was when he left the parking lot. He was found with the cocaine that was.
But they were willing to use deadly force, not running code, to capture him.
Your Honor, the TVI, to address that, I would just point out that Sergeant Moser was not driving any of the vehicles. He did not conduct the TVI.
Yeah, but he was, I'm talking about, that's the circumstances, correct?
That's correct.
They're willing to use deadly force on someone because they believe he was about to sell drugs.
They had probable cause to arrest him for possession with intent to
And they
distribute.
willing to use deadly force for that.
And in order to accomplish that arrest, Your Honor, to prevent Mr. Payne, who they reasonably concluded was armed, from leaving that scene, they got into a position where they had multiple vehicles near his vehicle. And when
They
they,
used deadly force.
when they
Or
initiate,
no, did they use deadly force?
I would disagree with the
You don't
the
think
character.
you don't think ramming someone's car is deadly force?
I disagree with the characterization.
I'm not characterizing
I-
anything. I'm asking you a question.
I disagree with that.
You disagree with what?
I disagree with the notion that a
The
tactical
notion?
vehicle intercept is deadly force.
What about a PIT?
It's the same thing. It's
Well,
accomplished in two
One is blocking and one
different.
is ramming,
Um,
right? And so blocking, if someone's driving quickly, that could be deadly force. Ramming one car into another, that's the PIT, right? And those were two techniques that were used that, I mean, I couldn't find frankly a single case where those techniques were used in a situation where there wasn't a chase, a high-speed chase. I couldn't find a single case. This was a highly unusual circumstance where the police were in unmarked cars with no lights, no announcement, no uniform, surrounding an individual trying to leave a scene. He was unaware, so he claims, that they were police officers. It seems reasonable to me, given that there was no announcement and no uniform and no lights, and it was nighttime. He's surrounded, and then he tries to drive away because he thinks reasonably that he's being potentially robbed or attacked by individuals who are not police officers, and then another police vehicle rams into his car. Those were the circumstances.
Those were the circumstances as claimed by Mr. Payne in his opposition.
Is there any argument from your client's side that those were not the circumstances?
Yes, and it's.
What facts that I just stated are disputed in the record?
In the record, there was two recordings that happened when Mr. Payne was in the hospital. He was interviewed by two different detectives, one from major crimes, one from internal affairs, about what had happened. And those are the audio files that were attached within the joint appendix. And when he's interviewed close in time, within a couple of hours of this incident, what he says to the police was that when that TVI was occurring at the stop sign, he knew it was the police because the lights and sirens came on. And as a result of that, I went up to the curb to try to get away. I sped up. I knew it was the cops because I tried to get away. I just sped off because I'm scared at that point, so I'm driving to try to get away. Mr. Payne admitted over and over again in those interviews that he knew the police were behind him, that they had their lights and sirens on, and that he jumped the curb at the stop sign to try to get away from the police. Mr. Payne doesn't want you to pay attention to that because he argues in his briefing before this court that, well, that was just a couple hours after this event happened, and so we shouldn't assign any importance to it. But admissions that he made within hours of when this happened, admitting to lights and sirens, admitting that he knew it was the police behind him, and admitting that when he experienced that TVI, it was during the time when he was trying to get away because he knew it was the police. He knew he had come to this scene to deliver narcotics, according to him, to a friendly face for $50. He didn't do it because he got scared. He's trying to leave the scene. He realizes that the police are behind him. Lights and sirens come on, and he jumps the curb to try to get away. That's why what happened to Mr. Payne. The TVI and the pit in this context are the same motion. A tactical vehicle intercept is bumping that back tire to prevent the car from moving forward. Sergeant Mosier did not commit the TVI.
Did he authorize it?
No, he did not. The driver is Detective Taramina. Detective Taramina conducts the first part of that TVI. They surround his vehicle in order to take him into custody. The
suit is brought against one party,
exactly,
just against Mosier.
only against
It's
Mosier.
not brought against the other people. It isn't, Mosier didn't do the intervention, did he?
Exactly, he did not. He was not
So
driving.
he was nowhere, the whole thing about the intervention doesn't concern Mosier because he's the only party to the case, and he wasn't even involved in the intervention.
Exactly, and I would also point the court to the Mendez case where the U.S. Supreme Court has said, even if something that happens early on in this encounter is a constitutional violation, which we don't agree that the TVI was a constitutional violation, but even if it was, according to Mendez, that purported constitutional violation does nothing down the road to make what is a reasonable use of force unreasonable.
If you wanted to go for the intervention, you would have added another party.
I agree, Your Honor.
There would have been an additional defendant or defendants involved in the case, but that wasn't here. There are just problems all through this.
Counsel, you agree that under Fourth Circuit precedent, that the mere fact that someone has a gun alone can't be the basis for shooting them?
I do agree.
Right. So if there was no furtive motion, you would agree that there was no basis for
I agree.
shooting him? You
I do
with that?
agree. I do agree. The issue here is the furtive movement, which Mr. Payne did not dispute in his opposition.
Well, that you said he said when he said, what is it, was the deposition in the record?
His entire deposition was in the
And
record.
don't we assume that the district court reads the record?
No, Your
We
Honor.
don't?
We don't.
Oh.
And this court specifically has ruled in the Cray case that the district court
What
does not
part
have
can
to.
they- What part can the district court ignore?
I'm sorry?
What part can be ignored?
They ignore the parts that aren't specifically cited in the opposition brief. The responsibility is on the non-moving party or any party to support or oppose at summary judgment, to point the
Well,
district court to the parts of the record
He
that would
wouldn't have
establish.
to, well, the district court, they're very able jurists. If the question is whether or not there was furtive motion, which is the sine qua non of the case, then you go to the transcript of what the person said, the plaintiff said. You don't have to search the whole place, like the whole history of where he was born and where he ate supper and all that kind of stuff, and went to college. But you go to what did he say at that moment, and he would say, I was just sitting there.
And
And that is inconsistent with furtive motion.
And
I
I
mean-
have no doubt that Judge Nachmanoff could have done that, but he didn't, and this court has said
Oh,
he
he-
doesn't have to.
Or you think he ignored that?
I don't think he ignored it. I think he looked at the parts that were specifically cited by the parties, which is what his obligation is.
No, it's not.
And he didn't find
No,
support for
wait a
for
minute,
Mr. Payne's
summary
claim.
judgment, you can just ignore what the plaintiff said about the very thing that's the core of the case?
And
And
the-
say, well, summary judgment because there's no fact here.
And the problem with it is that in opposing summary judgment, Mr. Payne's claim in his briefing was, it would have been impossible for me to be reaching for a firearm because there wasn't a gun in the car and my left arm was in a cast. And he points to specific parts of his deposition transcript that don't support that claim. That's where the district court doesn't have to say, well, it's not where the plaintiff says it is, but they attached their entire 196-page deposition transcript, so I'll just read it and see if I can find parts. I mean, these are, specifically, this court has ruled the district court doesn't do that. We expect the parties.
Now, this would come as a real surprise to district courts in this circuit if we said, no, it's not sufficient for you to rely upon the citations of the party opposing summary judgment. You've got to go through and read everything and fish out something that might be arguably relevant. That would be I can tell you, that would be a real surprise to the district courts in this circuit. And it would require them almost to take over the job of counsel, because counsel has a responsibility to help out district courts and to frame issues and to sharpen issues. And it's not fair to ask district courts to take over the job of the lawyer.
And it creates a situation where parties in opposing a motion or in trying to support their motion wouldn't worry about having to cite to particular parts. I'll just put it all in. The district court will read it all.
Just dump it. Just pay a big dump. Here's the whole thing. It's in here somewhere.
It also would create I would submit it would create a situation that happened here, whereas Sergeant Mosier had additional evidence they could have used at summary judgment to refute the claim, I didn't move, I didn't reach, if that was actually made in opposition by Mr. Payne in this recreation. The recreation established that if Sergeant Mosier had shot Mr. Payne while he was just sitting up in the car, the bullet would have had to have gone through the car door and not the window. But when the detective reaches with his left arm and comes back up, it exposes the back part of Mr. Payne's arm. And so we had this evidence.
This is in the record?
No, it's not, because it's
Why
in the
you tell-
record,
why
but
you
it
tell
wasn't,
us that?
because Mr. Payne didn't raise this issue properly in his opposition. And so there was nothing to refute with that additional evidence in the record. We've created a situation now where, because he gave the court his entire deposition transcript without citing to it where it was important, he's got a record that he can rely on appeal, but Sergeant Mosier has been denied the opportunity to have refuted that fact. If Mr. Payne had claimed in opposition, this fact your perception of what happened in that vehicle is genuinely in dispute. Here's why. Page whatever of the transcript is what establishes it. If it had happened that way, the way that it's supposed to happen according to the Cray case, then Sergeant Mosier's reply would have looked much different than it looked.
So one of the hallmarks of our appellate jurisprudence has been specificity. And it's not only that the specificity is required when pointing to the summary judgment record, and that point has been hammered repeatedly, but it's specificity when you object to instructions and to jury instructions. We say, raise the objection specifically. Point to the pages in the deposition testimony specifically. And we do that because the adversary system rests upon the ability of counsel to assist the district judge and the opposing party, both. It contributes to the efficiency of the process, both from the bench and from the standpoint of an opposing party. And you take leave of specificity and you're just off there in never land. And that's, I think, a big part of what's at issue here. And then there's the backup point that when you get specific, you realize that there was a lawsuit against only one party who wasn't involved in the intervention. You get to the point that the flashlight was there looking into the car. You get to the point that the refutation, such as it was, did not speak to the point of whether he could capably have reached into the console and pointed a gun and at the officer's colleague. And so there are multiple hurdles here, multiple problems, and there could have been, I think, it's not that there couldn't have been a case here, there probably could, and it doesn't seem to me that there needs to be a situation where we establish precedents. Well, officers can do this and do that and do this. It all, it seems to me, falters on very specific factors.
I agree, and those are more procedural factors with the way that Mr. Payne chose to go about opposing summary judgment. And the evidence, I think, shows.
Affirming the district court, and the district court, there is nothing about this case that needs to be said that, oh, the officers are here to do this, they can do this, they can do that, they can shoot on suspicion. There's nothing there. There was any disposition of this case does not need to be written in a permissive way. It doesn't need to be, because that's not what anybody wants.
I agree.
I don't want officers running all over the ranch, shooting on suspicion or whatever. This falters on some very specific grounds.
I agree with you, Your Honor. And ultimately, the plaintiff or Mr. Payne's, the way that he chose to go about opposing summary judgment creates a situation that limits him on appeal to argue the things that he's now arguing.
I want to ask my colleagues if they have further. Judge Gregory? Judge Gregory? All right.
Thank you.
Thank you, Mr. Clark. We'd like to hear from you, sir.
Yes.
Mr. Clark, you handled this case below, right?
Yes, I did.
Well,
I
you've
did.
been much aligned. So do you have a response?
Yes, I do want to address the issue of citing. If you look, we did attach our opposition in the joint appendix, and we did cite to the very page that the court is talking and appellate counsel is speaking about, where my client did, in fact, state that, yes, he had a cast in his arm and there was a dialogue back and forth. What it appears that they're disputing is that the portion of the transcript where he says, I was just sitting there, I wasn't doing anything, appears just a few lines above where the citation begins.
On the
So
same page?
So it's on page 127, and we cited to page 128, which is part of that entire dialogue that he's going through, where he's saying that he was just sitting there.
So this doesn't require any hunting by the district court at all?
No,
Right,
no,
in terms of
no.
looking at the whole place and the whole canopy,
Co-
right there on the
correct.
same page, right?
Correct. So for appellee to say that there isn't a genuine issue of fact because we didn't cite to the entire page, but only to the portion of the page, I think would miss the entire part of why we're bringing this appeal. We're bringing this appeal because there are issues at dispute that at trial would be admissible, that at trial would come out. And I agree with you, Your Honor, that yes, if Mr. Payne was pointing a gun at an officer or making a furtive movement towards an officer, then absolutely, the officer would be able to take the action that they took. But we brought this case because we don't believe that the officer was able to, one, view Mr. Payne from his vantage point, and two, there's a dispute because Mr. Payne says that he was not doing anything. He was just rammed. Yes, there are two different parts of facts. There are facts that right after he was shot and rammed by a vehicle and then brought in to be interrogated by officers, that he said to the officer, yes, I saw the lights. He didn't say that he saw the lights and started fleeing. He said he saw the lights after he had already been rammed. In the deposition, he says that he doesn't remember ever seeing lights. Yes, that's something that they can cross-examine him on at a trial. But what we're dealing with here is the summary judgment portion of it, and whether or not there are these issues disputed by facts.
What about the flashlight?
And the flashlight piece of it, Your Honor, there is no body-worn camera saying that to support Officer Moser
I mean,
or
is
even
it-
the affidavit of other officers.
How far away was the observing officer?
The Officer Moser,
Yeah,
I don't know the exact, I believe, I don't want to misstate where exactly he was. At least there's nothing in the record that points to how far away he was, but I know that he was not right on right up on the window.
well, if there was a flashlight shining in the car, which the officer would have had a pretty good opportunity to observe if the flashlight would reveal any movement to the console and any raising of the arm. It would seem to me that from his vantage point, that the officer would have seen all that.
So the problem is that the flashlight, unfortunately, the technology isn't out there to be able to have X-ray vision through an entire seat that's sitting there. So that's part of the issue that they're saying, that he was making this movement through the driver's seat and the officer's vantage point is behind the driver's seat, and therefore the ability for him to actually see what Mr. Payne was doing was obstructed.
Right, he wasn't standing right there at the driver's place, through that window.
Correct.
Right.
He was behind him and at night on top of another car that was also heavily tinted at the time, looking over that car, and in seconds makes a decision to shoot Mr. Payne based on what he heard, not based on what he saw. That's our dispute. Not based on what he saw, Your Honor, because I agree with you, but based on what he heard about Mr. Payne, and he made that judgment and decided that he was going to shoot Mr. Payne based on the fact that he was conducting a drug deal, not based on what he saw Mr. Payne doing that day.
You get in a situation where officers are supposed to delay, and in their case, the delay can be fatal.
Well, we're not asking for the officers to delay because, again, if the facts are true that he did see this furtive movement, that he is well within his right to take
But is
action
it
based on
Is
that.
it a genuine dispute? I don't see how he could not have seen. What was the flashlight into the car for?
Well,
You could see that he reached into the console?
and from where his vantage point was, Your Honor, there's no way that he can see. Now, of course, Monday morning quarterbacking, he's trying, and I don't want to get into the trial strategy, but him saying that, okay, I made a mistake and I shot someone. Let me try to figure out why I did that
everybody-
on the back end. But again, that goes to my point
Everybody's
that this should be
always-
the trial and the jury deciding this issue.
Everybody's always saying it's Monday morning quarterbacking. You know, it's interesting, well, this is Tuesday, so we're not having that problem. The other lawyer had some additional time, Mr. Clark, and I want to make sure you have whatever additional time you need to make your points.
Yes, Your Honor. And the last thing that I do want to say is, one, thank you, Your Honors, for having this oral argument. This is actually my first one in the Fourth Circuit after practicing for 11 years in Virginia, so I'm blessed to be in your presence today. But this case is important not because of what we're asking the court to do. We're not asking the court to change any existing law. What we're asking the court to do is to take a stand against district court judges making decisions based on factual determinations, especially when it comes to civil rights cases. The jury should be able to decide the facts if, in their opinion, there's no qualified immunity issue here, and there's facts that are a dispute that a reasonable juror can decide in the favor of the plaintiff. That's all we're asking for. We're not asking for the court to make any other decisions.
Facts are always in dispute. The question is whether they're genuinely so.
Correct. And
Most
here,
every case, that's not the case. Every police shooting I can think of, that it was undisputed there was some furtive action. The question is how you interpret it, but this one is different. Matter of fact, the Franklin case where the person had a gun right there with him, he had the gun. And then he said, drop the gun, and he pulled it out like this. And I said, no, that wasn't a qualified immunity. Because based on the way he handled it out, that person would have known that was not a furtive action to be aggressive to the police officer. So not only here, this is not new ground at all. Matter of fact, this would be new ground the other way, that a shooting is justified with a dispute as a furtive action. He says, you had a flashlight, and you're behind a seat, like you said, you were very calm, you said, take an x-ray light, yeah, is that something that can't be done? And then to say, and then you cite something that's on the same page or nearby, oh, you would have to go through hundreds of pages. No, you don't, it's there. We're talking about, that's what our frame was talking about, a constitution. That makes us, we live under a constitution in terms of just people going around and ramming cars. I know that person is not the plaintiff, but ramming the cars, because the Fourth Circuit said drugs and guns go together. So that would mean if that's the case, then every time somebody is a drug, well, I said he moved and shot him. But he was unarmed, but I saw him move. And it's, well, no, that's a factual question. What other reason would he have to shoot you? We don't know, but he did.
Thank you, Your Honor.
We don't ask who, it doesn't depend on who the district judge is. But in keeping with his general approach, this was a very, very fine district judge, and I think it is at least fair to say not only who the judge is, I think you have to go beyond that. You have to say, what kind of job did the judge do? That's the important thing, not who he is. But this judge is a fine district judge, did a very, very careful job. And that ought to make a difference.
I understand your position, Your Honor. Thank you.
Do you have anything further, sir? 'Cause
No, Your Honor. Thank you for your time.
We give both of you a lot of time.
Thank you, Your Honor.
Judge Gregory, do you
I
have
have nothing.
anything further?
May I be
All
excused, Your
right,
Honor?
we thank you, sir. We'll come down and greet you both.
Thank you.
Baldwin. Let's hear from you.
Good morning, Your Honors. Melissa Baldwin on behalf of the appellant, Jesse Glass. May it please the court. We are asking you to reverse Mr. Glass's convictions and reverse the district court's denial of his motion to suppress. Detective Lawrence used April's allegation that Glass had contraband on his cell phone to secure a residential search warrant. That application omitted that April lodged a very similar allegation in 2017 that Lawrence investigated and found no substantiating evidence for. When the deceptive omissions are corrected, probable cause is wanting for lack of independent corroboration for April's latest allegation. So here, Glass established that Lawrence violated Franks versus Delaware because Lawrence, with at least a reckless disregard, intended to mislead the magistrate by omitting crucial information to assess April's credibility and reliability. So he proved that Lawrence was reckless in making these omissions based on circumstantial evidence. We are asking this court to set aside the district court's factual findings on the intent element under the clearly erroneous standard for two reasons. And first is that the district judge labored under an improper conception of the reckless disregard standard under Franks.
But you admit we're here under a clearly erroneous standard of review.
Correct, Your Honor. And one of the avenues from which this court finds an error is clearly erroneous under Jimenez versus Mary Washington College is when a district court labored under an improper understanding of a legal principle. And the correct understanding of the reckless disregard principle under Franks is a legal determination. So if you are to determine that the district court labored under the incorrect understanding of reckless disregard, the factual findings made under that incorrect understanding are clearly erroneous and need to be set aside.
What was incorrect about the understanding? The district court found that there was no intentional omission and found that there was no recklessness.
The error here is in two forms, and one is that the district court...
That is the standard, isn't it? A recklessness or not negligence, but recklessness.
Right, recklessness, but the district court
That's a high
applied...
bar.
The district court said recklessness cannot be inferred. So if you look at the exact word, JA 483, where the district court said, or excuse me, it's JA 480, an inference of intentionality is insufficient, meaning that the district court discounted the mountain of circumstantial evidence that the defense presented showing a reckless disregard. And so you look, and so not only did the district court explicitly say an inference of intentionality is insufficient.
All right, now, the district court here heard from both Brown and Lawrence, didn't it?
Yes,
Lawrence was the special investigator, and he, as I understand it, Lawrence was the one that submitted the affidavit.
yes.
Am I correct about that? So you have the two individuals most directly involved, Brown and Lawrence. The district court has a hearing. The district court listens to Lawrence. The district court can read the affidavit, and it concluded, Judge Bell concluded that that there was no recklessness or intentional omission here. And this seems...
Yes, Judge Bell
seems
found there was
pretty-
no recklessness
seems pretty
here.
clean.
Judge Bell found no recklessness here because Judge Bell labored under the conception that recklessness requires Lawrence be actually aware that the risk would materialize. And that is not the standard for recklessness, and that impermissibly narrows the pool of qualifying conduct. And not only did the district court do that in terms of narrowing the pool of culpable conduct under Franks, but it also discounted the circumstantial evidence. So even applying the normal clearly erroneous standard, Detective Lawrence's testimony in this case was facially incredible and should be set aside on that basis. The district court in one breath said that there is no evidence to suggest that Lawrence's testimony...
How do you mean that it's facially
It is facially incredible that a
So we're
detective
gonna
with 20 years of law enforcement
Excuse me,
experience...
counsel. We're going to reverse the district court not only on clearly erroneous fact-finding, but we're going to reverse a credibility determination as well?
Well, I think it's clearly erroneous under either standard, and I think both apply here. I think there is both an incorrect understanding of recklessness, and I think there is facially incredible law enforcement testimony that it was erroneously credited. And you can do that by focusing on the district court's order itself, where the district court credited Lawrence's testimony. He didn't believe the 2017 allegation was relevant, but then the district court's own finding was plainly, that's the district court's word, it is relevant. So I think a law enforcement officer with 20 years of experience, who helps other novice officers draft search warrants, who worked on an FBI cyber task force for 10 years, is well aware that the fact the informant tip he's relying on to secure a search warrant came from the same source in his prior investigation, turned up no substantiating evidence, knows that that's relevant, knows that is something that a magistrate judge would want to know.
The Supreme Court has made a point of wanting officers to get warrants. And the more obstacles that we throw up in their face, the more they will seek to circumvent the warrant process. And in addition, the court has made clear that omission cases, or that misrepresentation cases, are more serious than omission cases. You've been claiming an omission in this case. So you've got the desirability of channeling police into the warrant process and not having them engage in rogue actions and doing this and this without going before a magistrate. And you've got the idea of, that this is an omission case and not a misrepresentation case. And you've got a high standard further under which the fact-finding takes place, which is not one of negligence, but which is one of recklessness. So that's a lot of hurdles to overcome, don't you think?
Well, I think in the sense
No,
that
you don't think.
yeah, I think a lot of things. But no, in the sense, we do. We want law enforcement to get warrants, right? But we want them to get warrants because we want a neutral and detached magistrate to be the one making the assessment on whether or not the historical facts demonstrate probable cause. So what we don't want is what happened here, which is that a detective recklessly takes that constitutional obligation away from the magistrate judge, who's unable to fill their role under the Fourth Amendment. And while I want to address the omissions, because while omissions can tend to be, a less serious form of than false statements, that is not always the case. Just think of exculpatory DNA evidence. So an omission can be just as culpable, just as offensive to the Fourth Amendment as an omission,
Well,
even though...
That really goes to the second prong of Frank's, the materiality prong, and even if we were to agree with you on the issue of recklessness, we would also have to find that had the omissions been included, we would need to reach a probable cause issue as well, is that right?
Yes, Your Honor.
Okay, and we would have to find that with the omissions, and there would have been a different analysis on the probable cause. So we have to reach both prongs. And we would have to reverse on both prongs.
Yes, both prongs have to be shown by preponderance of the evidence.
So, and you began by saying that this was an issue of law, and therefore, in response to Judge Wilkinson's question about standard of review, you said there was a legal error on the first prong. What about on the second prong? What was the error there?
Probable cause is a legal issue reviewed de novo, and the issue there is that once the information on calling April's credibility and reliability into question is inserted into the affidavit, at that point, a reasonably prudent person viewing these historical facts would need some independent police corroboration to believe her latest allegation. And the problem here is the affidavit discloses no such independent corroboration for a reasonably prudent person to credit April's latest allegation.
So you think the omission of this one investigation makes all the difference in the probable cause determination?
I think it's the most serious, but the other omissions include the estranged wife's status, the fact that the prior investigations that were included to cast suspicion on Mr. Glass, the fact that the outcome of those was that, you know, he wasn't even arrested in the 26 investigation. So we think the 2017 omission is certainly the most significant factor, and the other omissions demonstrate an overall deceptive pattern.
Well, if, with respect to the 2017 omission, the more previous investigations that are put into the affidavit, this goes to materiality and other points, that could be significantly to Mr. Glass's disadvantage. Even though cases are dismissed, a lot of investigations are discontinued and the cases are dismissed. It doesn't imply that there's some sort of innocence. There can be a million reasons to dismiss something, and the most common one being that the witness has gotten cold feet or what have you. But isn't it quite possible that if all of these different investigations were included, including the 2017, that would have worked to Mr. Glass's disadvantage, because a magistrate would say, my gosh, we've had these different investigations of this over a period of years. Where there's smoke, there must be fire. And in other words, I'm not sure how something can be material if its inclusion could have been inculpatory, in the sense that it would prove that they had a history of questioning what his behavior was.
Judge Wilkinson, the answer is, this court's precedent says the only thing that is included in reexamining probable cause is the omitted information that the defendant has shown was recklessly omitted. In other words, all the investigative facts that Detective Lawrence but chose to omit in his application do not get included in a reassessment of probable cause in the Franks analysis. And this court said precisely that in Lull, if you look at footnote 3. So in this case, where, you know, perhaps there, with the idea that there was the smoke signals suggesting fire, well, those same smoke signals were present in the 2016 investigation that turned up no substantiating evidence.
One thing I want to ask further about here, this comes up to us in an unusual sort of posture. Normally, we get these questions of these Franks v. Delaware questions. They come up to us on conditional guilty pleas. At least a good many of them do. This comes to us after a jury verdict, and it seems to me that the difference at least is worth noting, because we have a trial and a jury verdict, and the depictions here are of child sexual abuse, and based upon the descriptions of some of those pictures of child sexual abuse, they're absolute filth. And the fact that a jury looked at this and found that and found them, the individual deserving of conviction, at least there is some value, I think, to taking into account the effort that has gone into the trial and the jury's verdict. It's just a different situation where you're dealing with a conditional plea. I'm just not willing to say, oh, well, it doesn't matter, we can just take the jury's verdict and just lay that to one side. Doesn't really, it doesn't really matter, despite the fact that this probative evidence was put on. And there was probative evidence that was put on as a result of the search. And then normally, the Supreme Court has talked not only about preserving the value of warrants, but in terms of the exclusionary rule, they've been talking about increasingly the need to honor the desire of our judicial system to hear, and of juries to hear probative evidence. And you're saying, well, we're gonna circumvent, we're gonna throw out this attempt to get a warrant, and we're gonna disregard the jury verdict. We're gonna disregard the value that is, the criminal justice system places upon probative evidence in a trial. We're gonna do all that under a clearly erroneous standard. It just, it gets to the point that we're running into all kinds of problems.
I mean, I agree that the Sixth Amendment right to a jury trial is important, but so is the Fourth Amendment, and hindsight is not probable cause. And, you know, in terms of the conditional plea, I can't speak to the plea
I
negotiation.
agree about the Fourth Amendment, but in many instances, the Fourth Amendment case, the Fourth Amendment problems can be brought up later in the 1983 suit, but they don't necessarily require taking a jury verdict, which heard very probative evidence, and it's of a very damaging nature in terms of the child sexual abuse that went on, and saying, well, no problem, we're gonna do it all over again, or whatever. And I think that's going against what the Supreme Court is trying to indicate is the value of sparing. Not that the exclusionary rule still holds firm, there's no question about that. But the Supreme Court has said there needs to be a measured and somewhat sparing use of it. And it seems to me we're doing that, we're doing it in the face of a clearly erroneous standard of review. And that's to me, that's just really troublesome, all the things you're asking us.
I would submit, Judge Wilkinson, that a law enforcement officer recklessly deceiving a magistrate into issuing an illegal search warrant is precisely the wrongful, culpable conduct the exclusionary rule is meant to deter from happening in the first place. And my time has expired, but if you'll indulge me for 15 seconds, I will say, part of the problem with these search warrants, things go wrong. People get shot, pets die, people die, and so we should just be very careful about adhering to the probable cause determination. If it's warranted, if there is a reasonable belief there's evidence there, sure. If there's not, do some more investigation until you get some. I'll reserve the rest of my time. Thank you very much.
Hold on for a second. I always like to ask my colleagues if they have, everybody gets to, Judge, do you have any?
No.
Okay, we thank you very much. And Ms. Ray.
May it please the court, Amy Ray for the United States. Your Honors, the district court did not clearly err in finding that Detective Lowrance did not personally recognize the risk of misleading the magistrate or the judicial officer in this case. The district court made a credibility finding, and the standard is, and this court's decisions in Pulley and in Haas make clear that it is a subjective standard. There's a requirement that this detective have appreciated the risk of misleading the magistrate or the judicial officer when the detective omitted the facts that the defendant asserts were improperly omitted under Franks. In this case, Detective Lowrance testified consistently that he did not believe those facts were relevant. And while we may look at, and the district court did with respect to the 2017 investigation, said, I personally would have thought that was relevant. Detective Lowrance testified that he did not believe that it was relevant, and the district court credited his testimony after observing him, after listening to his entire testimony. And that determination is not clearly erroneous if it is reviewable at all. So in then turning to the materiality prong, in terms of the materiality prong, the district court did not err when it found that even if Detective Lowrance had included the information about the 2017 investigation, it would not have defeated probable cause, because probable cause depended, and I want to note that April Glass's report in this case was highly specific. She gave information about where they would find the devices, and not only that, but where on the devices they would find the images. She explained how she came across them. In child pornography cases, we can't be surprised when earlier investigations end up not revealing information. It can be deleted, it can be destroyed. And so in this case, the judge also, Judge Bell, found with respect to materiality reasonably that a magistrate or a judicial officer would have recognized that in talking about 2016 and 2017 investigations that he was investigated, the fact that the detective omitted that he had been convicted or even charged, which he was charged in the 2012 contact offense, it's not material because a judge would have inferred reasonably that it didn't yield a conviction. So the judge.
If it had yielded a conviction, that would have been noted.
Exactly, Judge Wilkinson. So the district court got it right on both intentionality, there was no clear error, and the district court reasonably found that even had the facts been included, it would not have defeated probable cause.
On the question of intent, the district court says that Detective Lawrence was, and I'm quoting, was not seeking to mislead the court or obscure his rationale for omitting the challenged information. So it does seem to me that the district court is requiring intentionality and isn't really analyzing the question of reckless disregard on the first prong of Franks. That the district court has collapsed these two separate scienter prongs under the Franks analysis and is not separately analyzing intent and recklessness, because the summary of the determination on the first prong only really goes to the question of intentionality.
Your Honor, I think that the difference is, or the distinction that I would suggest, is reckless disregard in this context requires intentionality.
So there's no difference between intentionality and reckless disregard under Franks?
There is, and here's the distinction. The distinction is what the intent, where the intent applies. So for example, if you intend to omit the information, that's intentional, but the intent with respect to reckless disregard is that you intend to mislead, that you believe, you know there's a subjective awareness that the facts that you're omitting could reduce, and so the recklessness is the recklessness in omitting facts that you are aware have the potential for misleading.
So why isn't that just intent?
I can only tell you, Judge Berner, that this is how the cases describe it, and I would refer, Your Honor, to United States versus Haas and United States versus Pulley. And I will acknowledge that in handling this case and in researching, it was interesting to kind of look at the subjective element on this Franks inquiry with respect to reckless disregard. But of course, reckless disregard, and even Borden says this in the Supreme Court, it always requires some subjective awareness of the risk. And that's the same here. So intentionality would mean I intentionally omit and I intentionally mislead. And recklessness means I know there's a risk and I'm reckless with respect to that risk. But there is a subjective awareness requirement. And the district judge in this case made the finding that Detective Lowrance was not aware that if these omissions would risk misleading the judicial officer.
Well, to be fair, that's not what the district court said. The district court said that the detective was not seeking to mislead or obscure. So was not seeking to mislead or hide his rationale. So I don't find an analysis of reckless disregard. I do see a conflation of the two prongs, or the two different subjective intent requirements. I hear what you're saying. I think what you're saying is that our circuit precedent conflates the two and essentially creates one requirement. But that's certainly not what the Supreme Court has said. And we have plenty of precedent that does suggest, including my colleague Judge Wilkinson's opinion in Coakley, which talks about them being two different requirements.
They are. I don't think that it is conflated. So I don't think that's true. As I said, I think that on intentionality, there has to be an intentional omission, and there has to be an intent to mislead. And on reckless disregard, there has to be an awareness of the risk of misleading. And actually what it says in, I will refer this court to United States versus Haas. And what Haas says is, reckless disregard is established by evidence that an officer failed to inform the judicial officer of facts he knew would negate probable cause. So the district court's explanation here, I think, was on all fours with that. And that's United States versus Haas. I don't know what else to say, except that I do think there is a difference, I think the district judge got it here correct. That said, even if the district court had erred in its articulation of the standard, what the district court found, as a matter of fact, was that Detective Lowrance made at most an innocent mistake. And it is undisputed, no matter how we articulate the standard, consistently what has been held is that a negligent action is not enough. An innocent mistake is not enough. So the district court did not just find that he didn't intend to mislead. The district court also said it was at most an innocent mistake. And that is exactly what this court held in Kolke. In this court said that at most the record revealed that the officer in that case believed that the information was irrelevant. And that's exactly what Detective Lowrance testified to in this case, and that's exactly what the district court found wasn't sufficient.
Seems to me the real dividing line here is between negligence and recklessness.
Sure, yeah.
And that's with respect to the first prong, before you get to the materiality. We can talk about intentionality here, but the real difference is between recklessness and negligence. And the district court's finding nailed that. And it said what this was at most was an innocent mistake. And that's pure and simple negligence.
Right.
And that falls short of the recklessness standard.
That's right, Your Honor. And I do think that in this case, that was the question. Nobody suggested that Detective Lowrance met the intentionality prong with intentional conduct, truly intentional conduct. The question was it reckless disregard or was it an innocent mistake? And the court wrestled with that when it described and distinguished United States versus Lull, which is, in my review, the only case in which this court has applied an inference, although it didn't articulate that it was applying an inference of recklessness. This court in Kolke suggested it probably couldn't be inferred, but if it could be, and this is consistent with other circuits that have held that recklessness could be inferred, it has to be a fact that is clearly critical to the probable cause calculus. And so in Lull, the district court in this case did consider Lull, which was also that same question of is it reckless or is it an innocent mistake, and explained why Lull was so much worse and one could infer recklessness in Lull, where one could not in this case, because Lull involved a lie that had just happened that was relevant to the crime itself. The informant had been arrested and charged by the time the officer made his affidavit. In fact, had been arrested and charged only a half hour earlier, yet the officer didn't include that information in the affidavit. That is worlds away from a wife who has, estranged wife, whatever, that she has made an allegation highly specific.
Seems to
And
me that in terms of this dividing line between recklessness and innocence, mistake, that the district court's finding here would rest substantially upon his impression of Lawrence's testimony.
Yeah.
And to the district court's credit, he didn't just brush this off. He listened to both Brown and Lawrence. And you're in a district court is in a really good, much better position than we are to assess credibility with that, with respect to the affidavit, and what was included and what was omitted. And so that's one thing that I think is really important on making this a matter of negligence, is that the negligence finding is not only a matter of finding of fact, but it's backed up by the credibility findings. You've got a finding under the standard, and then you've got the credibility finding. And the other point I was interested in, I'm not sure that it's critical to the case, but so many of these Franks v. Delaware questions seem to me to come up on conditional pleas. And this one comes up for, after a jury verdict. And there's, the images of child abuse here were really vile. They're really very, very disturbing. And so I'm thinking, given the Supreme Court's emphasis upon the value to the judicial system of having probative evidence placed before the jury, that it should make some difference, the fact that this is a product of a jury verdict, and that the effort here is to exclude probative evidence of serious child abuse. And that kind of holding would at least catch the Supreme Court's interest. You see what I'm saying?
I do. I mean, I don't think that the jurisprudence in the Fourth Amendment context suggests that this court reviews it differently post-trial than it would pre-trial. So I don't think that this court, I will say, though, that the exclusionary rule, what the Supreme Court has said over and over again, is that its intent is to deter misconduct, right? The intent of the rule is to deter police misconduct. And Franks, that's the intent here. That's why we draw the distinction between negligence and recklessness. And so there has to be evidence, and the district court did make a credibility finding after listening to Detective Lawrence's and you know, observing his demeanor and all of the rest of it. I don't know if this court has any questions about the other two issues.
I have a question, Ms. Ray.
Sure.
Well, I'm glad you said in the last part that the law doesn't make a distinction in that regard, whether it's a trial or Franks without a trial. But our framers were, you know, they were pretty ingenious in that they didn't trust government. They clearly didn't. I tell lawyers, I said, what rights are there for the government? That's why your job is supposed to be hard, because none of the Bill of Rights protects the government. None of it. You know why? Because the government will assert its power. It's the people. So when we talk about searches and seizures, the protection is from one's home and property, not what ultimately might be exactly in terms of the prosecution and those questions. But here's a question I had. Under this situation where we can say what the officer said, I know the other allegations, and it turned up it didn't come to fruition, but it could be 20 times someone has done this. You know what? I've been in their home and I've seen this. I know they're doing this. The warrant. You keep on. So you don't tell the magistrate, say, well, this is the 20th time that they've done this. at some point, isn't credibility a key to whether or not this is a reasonable intervention in someone's home? If you take that out,
Yeah.
what is that have to be intentional? That have to intentional, or is that reckless? What does become because that's an important distinction. Because basically, another officer would have had a different view about putting this
Right.
in, right? So we know
Yep.
that. So fortunately for you, it's not a reasonable officer because you may have some problems, right? It's just that you'd say it's just that individual
Gotta be
subjective.
subjective,
That'd be
right.
subjective.
Right.
But at what point do you get to the point where we have migrated to the point? Wait a minute, this is just. You have to put that in there because otherwise, you see what I'm saying?
I do. I mean, I think for one distinguishing fact that I think is really important in this case is there's no evidence that April Glass ever lied, right? That's the
Right,
distinction
right,
between this case and Lowell.
I mean, just so I say, it did come to fruition in terms of,
Yeah, but
Yeah,
even in the past, in the
Right.
past, I mean, there's no evidence that she was ever telling the false. In fact, the evidence, if you view all of it, suggests
Right.
he was destroying the evidence.
right,
Conveniently. Of course, Your Honor, I think that at some point, if there were 20 investigations and they were made by the same person, and, you know, I'm sure there is some place. What I think, though, that is important when we talk about the Fourth Amendment and the framers is one of the things that the Supreme Court has held, and it's important when we think about what is the purpose of the exclusionary rule. So, yes, it's to protect individual rights. And then also to protect the community, the court has held that there has to be some deterrent value in excluding probative evidence. We don't exclude probative evidence. We do exclude probative evidence, right, all the time when it is police misconduct, and that is appropriate. But where the balance in the Franks inquiry, and actually, you know, in some ways, the fact that it includes recklessness is, you know, that's something that's in the defendant's favor. It could have come down, the Supreme Court could have said it requires intentional misconduct because that's the purpose of the exclusionary rule. Instead, it includes recklessness. But it includes a recklessness that takes into account the subjective intent of the officer. And that's what this court held in Haas and recognized. And so to that extent, yes, I agree that at some point along the way, perhaps the recklessness standard would be satisfied and it would be held material. This case just isn't there. We're not there in this case. It's not that close. And so I think that's the way I would respond to Your Honor's question, and I hope that answers it. I think it is a balance. I absolutely recognize that the Fourth Amendment is intended to protect defendants' rights and individual rights. Thank goodness they exist. I agree, government is suspect. That is kind of was some of the context of the framers, the distrust of England, right? And authority, appropriate. But in this case, on these facts, we're not there.
I do have a question about the assessment.
Sure.
In considering the various assessments to impose on Mr. Glass, the district court did note that Mr. Glass was indigent, that he had recently suffered serious physical impairment. I understand he's also post-retirement age, and so those facts were acknowledged, but then in imposing this not insignificant assessment, the district court said, well, Mr. Glass could pay for it. Why was that appropriate?
Your Honor, it was appropriate because under 2259A, the Amy, Andy, Vicky Act, it shall impose an assessment, right? So it's not a may, it's a shall impose an assessment. And then it gives a ceiling of $17,000 or $35,000. Now, it does require that the district court consider the 3553A and the 3572 factors. In this case, the district court went through pretty carefully the 3553A factors. He considered the seriousness of the offense. He considered Mr. Glass's medical history that Your Honor just described, referenced. He considered his military service, and he considered his he twice violated probation on bond and said, you know, Mr. Glass has shown that he's going to be recidivist. So the difference between the assessments under the Justice for Human Trafficking, the 3014, and the difference in the Amy Vicky Andy Act is one is required, it's mandatory, and one is also based only on indigency. So the district court adopted the pre-sentence report, which showed that Mr. Glass earned over $71,000 in 2021, the most recent year of his earnings. And he said, yeah, I'm gonna find that he's indigent for purposes of 3014, but I'm also gonna find that he can pay a modest $5,000. And I say modest not because $5,000 is easy for all of us to pay. Oh, I see my time is way over. May I finish answering the question?
Absolutely.
Judge Wilkinson, thank you. The district court recognized that based on the $71,000 that he had earned, and he hadn't really gotten in medical treatment, that $50 a month after he got out was reasonable. So he had the opportunity to impose, with the 4 offenses, it would be 35 times 3 plus 17, well over $100,000 assessment, and he chooses $5,000. And he goes through the 3553A factors. He does it all pretty quickly. If you look at the sentencing transcript, he goes through all the factors. He also knew, by the way, that the defendant didn't want an assessment, so he was considering this. And Chavez Meza makes clear that this court should consider the entire record and just find whether or not it was the district court made a reasonable assessment, and one that would allow this court review. And I think the judge did that in this case, Your Honor. Okay. If Your Honors have no further questions, the government, we request that this court affirm the judgment of the district court. Thank you so much.
Ms. Baldwin, you have some rebuttal time here.
Thank you, Your Honor. So I'd like to address 2 points that the government brings up. First is the idea that the Haas case reimagine the reckless disregard standard that is stalwart law in all of the criminal law treaties, and that was applied by this court in Lull. And the language she cites to in Haas comes directly from the Miller versus Prince George case. And it's important because in the Miller versus Prince George case, that statement about reckless disregard can be shown by a cop omitting information he knows would negate probable cause came about because that is exactly what happened in that case, where the plaintiff alleged that the cop omitted the fact that he was seeking an arrest warrant for a white suspect, but omitted the fact the arrest warrant he was seeking was for a black man. So in that case, he knew by omitting the race that would negate the existence of probable cause. What it did not say that one way of showing reckless disregard is the only way of showing reckless disregard. And to the extent Haas said that, it contradicts the holding in the Lull, and under the prior precedent rule, this court is bound to follow that earlier holding. Reckless disregard requires a subjective awareness that a risk accompanies omitting these information from the warrant, not an awareness that the risk will actually materialize. But that is what the district court held the defendant to in this case, and why the district court's findings are clearly erroneous. Now, second, on the point where the government relies on April's details within her allegation itself as sufficient corroboration. The government doesn't supply any authority for the notion that an unreliable source can generate probable cause by supplying details, and common sense suggests otherwise. Just think of ChatGPT. We all know it hallucinates cases, and we all know that it can spit out very compelling factual patterns, even quote the holding. But it is reckless for a lawyer to rely on that and not doing the bare minimum of checking and seeing if that case exists. Detective Lawrence had opportunities and investigative steps he could have taken. That tip included information such as usernames. They could have set up a sting to use the usernames to try and elicit him into a conversation. He could have gotten an administrative subpoena with a lower requirement than probable cause to verify some of these details. Other people lived or visited that house they could have interviewed. None of those was taken.
I thought he did investigate April's credibility as a witness. That Lawrence did.
I'm saying Detective Lawrence did not investigate the details the government seeks to rely on to corroborate her allegation. And absent the corroboration of details in her allegation, a reasonably prudent person would not credit her latest allegation. And it goes to the recklessness, the fact that most of the investigation that Detective Lawrence did do into April turned up problematic things that he elected to omit from the magistrate's consideration. such as the fact that she had the misdemeanor shoplifting charges, was under investigation for another. She told him in an email communication that, she had gotten Mr. Glass in trouble for an assault in Yadkin County, called up Yadkin County, was like, hey, what about this arrest? They're like, we have no idea what you're talking about. He did look into April, and, there were many, many red flags, and instead of either doing more investigative work or at least doing an honest, truthful presentation of what he found to the magistrate, instead he submitted a deceptively drafted affidavit. And so here I would submit this is worse than Lull, because here we have an affidavit where you can see, and it's just like the Ninth Circuit Perkins case, where this officer cherry-picked out the facts he found to bolster probable cause while omitting those facts that he found out that dispelled the suspicion that otherwise attached. We would ask this court to...
Everything you said was at odds with what the district court found.
And the district court was clearly erroneous for finding that.
Okay, thank you.
Thank you very much.
Roger, did you have any? All right, I wanted to thank you. I see you're a court-appointed FPD, and really would like to express the appreciation of the court for your argument. And, Ms. Ray, we're always pleased to have you as well. Both of you have done a fine job, and we'd like to adjourn court and come down and greet counsel.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.